Good afternoon, everyone. We're just going to give a minute for everyone to get logged into the call, and we'll start momentarily. All right, so we are a minute after our start time. We are expecting a few more guests, but we'll get started in our introductions while we wait. So first off, thank you for joining us today for our virtual leadership luncheon. We are grateful for our presenting sponsor for today, CGA Law Firm. This event would not be made possible without them. Rebecca Countess, the marketing director for CGA, is here with us today, and I'd like to welcome her to the screen to just tell us a little bit more about CGA before we jump on into the program. Rebecca.
Thank you so much for coming. We are delighted that you are here, and I'd like to take a moment to just tell you about CGA Law Firm. We are a full-service law firm. We have over 30 attorneys and 34 legal professionals, and some areas of law that we cover are business, estate planning, elder law, family law, health law, labor and employment, litigation, mediation, municipal, real estate, school, bankruptcy, and debt restructuring. The CGA Bankruptcy and Debt Restructuring Department is ranked Tier 1 each year by the U.S. News and World Report for the Harrisburg region. I would challenge you to find 2 attorneys who have a greater depth of knowledge on their subject, are kinder, or could get you better results than the 2 exceptional attorneys that you're about to spend time with. Casey will tell you more about these 2 wonderful attorneys. Back to you, Casey.
Thanks, Rebecca, and thank you again for your support. Before I introduce our 2 attorneys for today, just a few housekeeping items. Attendee lines are on mute, but if you have questions for the presenters, we will be taking those throughout the program today. Please feel free to use the chat feature or the Q&A feature along the taskbar. Enter those questions and we'll answer those as those come in. If you experience any hearing issues with the webinar, try dialing in through one of the telephone lines in the registration confirmation you received when registering. So let me first introduce Haley. Haley Rohrbaugh has extensive years of legal experience as a paralegal in both Florida and Pennsylvania. In 2010, she joined the bankruptcy department at CGA. And as a paralegal, Haley worked closely with our other presenter today, Larry Young, and Brent Diffenderfer, who are 2 of the only attorneys of 25 in the Commonwealth who hold the consumer bankruptcy specialist certifications. Haley considers her years of working with them to be extremely valuable, and she continues to enjoy their mentorship. And Haley's primary focus is in Chapter 13 and Chapter 7 bankruptcy, but she also assists clients in business formation and representation, collections, and estate law. Haley attended Fairfield Area School District most of her life, but graduated from high school in Fort Myers, Florida. She is a graduate of Florida Gulf Coast University and holds a Bachelor of Science degree in business. And then after moving back to Pennsylvania and while working as a full-time paralegal at CGA, she worked to complete her Juris Doctorate at Widener University Commonwealth Law School via their Evening Division program. And then our second presenter for today is Mr. Larry Young. Larry is a shareholder with the CGA Law Firm and currently chairs the firm's bankruptcy and debt restructuring group. He focuses practice on consumer bankruptcy matters, Chapter 11 and corporate reorganization, debt restructuring, and workouts. Larry is certified as a consumer bankruptcy specialist by the American Board of Certifications, and again is one of only 25 attorneys who have that designation through the Commonwealth. He's also a solicitor for the Manchester Township. And Larry's experience is in handling representation of consumers in Chapter 7 and 13, Chapter 11 filings for small businesses, business reorganization, liquidation, and debt restructuring, acquisitions of distressed assets and debts from bankruptcy, foreclosures and related real estate transaction actions, Chapter 7 trustee work and related litigation, and finally, representation of farmers in the Chapter 12 bankruptcy. So with all of these great credits and marks, I would like to turn it over to our wonderful attorneys for today, Haley and Larry. Thank you both.
I think I've correctly unmuted myself. It's a pleasure being with you all. Haley and I are looking forward to this to discuss bankruptcy. Regretfully, it may be a little bit dry. We're going to try and make it relevant to business people who are possibly dealing with somebody who is in bankruptcy, as opposed to a group of lawyers thinking about how am I going to file a case. We encourage you to ask questions. Haley is going to be monitoring things, and if there is a question, we'd rather handle it as you go along instead of waiting till the end when half an hour after we've covered something, the question may no longer be relevant, or we have to remind you what the issues were. What I'd like to do first is discuss the existing Chapter 11 rules before the small business subchapter. They call it Subchapter 5, Subchapter V, but before these new rules were into effect for small business bankruptcies. And the reason that small business bankruptcy statute was enacted is, as I go through the existing rules for Chapter 11, you will see how they are cumbersome and expensive, time consuming. There is no shortcut. They're quite difficult. So first of all, the way that the statute existed before the new small chapter, Subchapter 5 was installed, there was no debt limit. You could have a small corporation that owed $1, or you could have a Texaco or a General Motors that owed millions, if not billions. And the trouble is, it was the same one size fits all for regardless of the size of your business debtor. You could have individuals involved in Chapter 11 if they owed more than a certain amount, usually in the $2 to $3 million range. But any size corporation or LLC, if it wanted to reorganize, had to be in Chapter 11. It could not go to any of the other chapters. Chapter 13 is a reorganization chapter, but it was only available for individuals, and then only available for individuals that owed less than that $3 million cap. So the process was you fill out literally 50 pages worth of information. The United States Trustee, which is an arm of the Department of Justice, would get involved and try and form a creditors committee. Your creditors would get together and decide, how they wanted to be represented, hire their own lawyer, hire their own accountant. You would come in and the debtor would try and propose a plan of reorganization, but it was a real tug of war because you had this triangle, if you will, of the debtor in possession on one side, the creditors committee on the other, and the game was sort of being refereed by the United States Trustee. And if there were significant problems, the US Trustee would become involved. Drafting a plan was often a 25 to 50 page exercise. Even for a small business, you were looking at something in the neighborhood of 15 to 25 pages. And you had to do both a plan and a disclosure statement, which talked about all of your relevant financial information, gave an outline of what you were going to try and do to pay people, how much you thought you could pay them, how much time you thought it would take to pay them. And usually there was a limit of 5 years that you couldn't go much beyond that, although you could negotiate with your creditors for almost anything. The time it would take to get a plan confirmed was usually, I say usually, 4 to 6 months, although I've seen it take 1 to 2 years. And the cost, this is where you need to be sitting down if you are going to be a debtor. Even for a small business, you were paying $25,000 to $50,000. And for a larger, more complicated case, you could easily pay $50,000 to $100,000 in legal fees. And so you could see that it really wasn't feasible for a small business to be reorganized unless you really cut corners. Now, we will be discussing the role of a trustee in this new Subchapter V or Subchapter 5, but understand the role of the trustee in the ordinary Chapter 11. And by the way, there are trustees in every chapter, 7, 11, 12, 13. But the role of the trustee in the garden variety Chapter 11 business bankruptcy was only if something went wrong, because normally the debtor, called a debtor in possession, maintained control of its assets, ran the business, proposed the plan, drafted through their lawyer the documents, and there was no trustee other than the U.S. trustee, the Department of Justice, involved. But what happened if the debtor was guilty of malfeasance or a complete lack of capable management? That's where the bankruptcy court could appoint a trustee to step in and literally oust management and take over the operation of the business and propose a plan of how this debtor, no longer a debtor in possession because it wasn't possessing itself, it was now in the hands of a trustee, was going to reorganize. I've had that happen probably half a dozen times in my career, where I've been asked to step in and take over an ailing business and decide how to restructure. And usually when you get to that level where a trustee is being appointed, it's a liquidation analysis. It's no longer a restructuring or how many pennies on the dollar can I create. It's a matter of what can I sell, who gets paid, what secured creditor gets paid, what taxing authority gets paid, and the unsecured creditors get whatever is left. The trustee in that case is supposed to be disinterested, totally independent of the debtor. So it can't be an entity that's related to or is a creditor of the debtor. And frankly, the trustee can often be adversarial. I mean, imagine if I were to come into your business and say, I've been appointed by the government to take over the running of your business. You may go home. You may not contact your creditors. You may not contact your employees. You no longer have signing authority over your bank account. That is now me. I own your business. I get to run it, and you get to do nothing about it. So it was often very difficult. And I've had to do it, but I've actually had to call the local police about removing existing management and making sure that they didn't come back on the premises. Normally then my job would be to sell the assets unless there happened to be a confirmed plan. But usually if there's a confirmed plan, the management has done enough that you don't appoint a trustee. So I'm usually liquidating assets and trying to pay everybody whatever pennies on the dollar can be paid. So that's what an existing current Chapter 11 looks like. And that's where in 2019, Congress felt there was the need for a small business Subchapter 5, Chapter 11. And there's some amazing, interesting features about the Subchapter 5 bankruptcy. And that's really what we want to discuss today. Why is it here? Well, you can see the cumbersome nature of the existing Chapter 11 and the fact that this new streamlined procedure, it's going to cost less, it's going to take less time, and for the small business, it's going to be a godsend. And I will tell you that at least in central Pennsylvania, there are relatively few large businesses that need the kind of Chapter 11 that General Motors might need or Texaco might have needed. Most of what we have in central Pennsylvania, at least in York, Harrisburg, I don't want to speak about Lancaster necessarily because there's some large companies there, but they're mostly family-owned businesses, mom and pop enterprises that need some assistance on occasion, but don't have the ability to write that check for $50,000 to get themselves reorganized. In some cases, they don't even owe their unsecured creditors that much. And in many cases, they're just trying to deal with their bank. So let's talk about Subchapter 5, this new law. It was enacted just before COVID hit. It wasn't intended to be the relief bill for the COVID period of time from March of 2019. It was effective in February of 2019 and originally had a debt limit of approximately $2.7 million. Congress realized that it had an opportunity to create this new law to be effective for the pandemic and immediately raised the debt limit to $7.5 million so that you could be a small business as long as you owed $7.5 million or less. And that's the total aggregate debt. That includes if you've got subsidiaries and related corporate entities. And there have been cases about that. So if you've got an umbrella organization, you take all of the debt in the aggregate. And normally, the smaller the debt, the easier it is to resolve the debt. You have usually less tension, less anxiety. And when the debt limit was raised to $7.5 million, you were able to include more businesses that would now be able to take advantage of this new Subchapter 5 opportunity. The debtor can't be forced into Subchapter 5, and that's one of the critical issues. You could be forced through an involuntary bankruptcy, but Subchapter 5 is an election that the small business debtor gets to make. And what is different, and we're going to discuss the role of the trustee near the end, is that instead of the trustee being the alternative to a debtor who can't get it done, the trustee now is appointed in these Subchapter 5 bankruptcies in order to assist and facilitate the debtor in making a plan workable. So you're not looking at that 25 to 50 page plan drafted by an expensive attorney who's looking to try and resolve, expensive debt. You're looking at a smaller business, smaller debt footprint, if you will, and the trustee, and we'll discuss the trustee's role later, but the trustee is actually part of the solution instead of the alternative to a debtor that can't solve its own problems. One of the features in regular Chapter 11 is that the debtor had 120 days to file a plan and could extend that up to 180 days. In Subchapter 5, the debtor is supposed to get a plan filed within 90 days. Now, it can be extended, but the extension is the exception rather than the rule. And in the regular garden variety Subchapter 11, the extension was almost the rule. And you could get that extension just by asking it. You didn't have to justify it at all. In Subchapter 5, there needs to be some justification for why you need this extra time that in theory, the statute doesn't think you're going to need. Additionally, whereas before in regular Chapter 11, you had to file both a disclosure statement, which was itself, as I said, a 25-page document, and then a plan of reorganization as to how you were going to handle the payment to creditors. You're allowed to do one document in Subchapter 5 so that you're combining the two, putting all of the information in one document that is in theory a little more readable. There's actually a form, a sort of fill in the blank form, that instead of running 25 to 50 pages of legalese, is in a much more readable fashion that in theory, the average small business creditor can review the plan, determine how it's being treated, and it's much more workable and feasible for the creditor to analyze what the treatment is that they're being afforded. Now, Subchapter 5 is entirely voluntary. You can't be forced into it. Although for many small businesses, it's a very safe haven. And if I had a client with that little debt, but needed to reorganize, I would never suggest they go into an ordinary Chapter 11. Subchapter 5, the rules, and Haley's going to discuss them, are much more advantageous to the small business creditor. Oddly enough, you don't actually have to be open and in business to qualify for Subchapter 5. There were discussions and cases about did you have to be an ongoing enterprise, but during COVID, a lot of small businesses shut down. And the question was, well, if you've shut down, can you still qualify? And the decisions came out to say that Congress didn't say you had to be open. You could have closed your business and still qualified for Subchapter 5 in order to take advantage of this debt restructuring opportunity. The debt limit of $7.5 million was initially just increased for the period of a year. It's now been extended again to March of 2022. And there's a side of me that says, I think Congress may like that number enough that there may be a more lengthy or even permanent extension of that number so that more small businesses can be picked up under the umbrella of Subchapter 5. It can be an individual, it can be a small business. So as before, where if an individual owed more than $2 to $3 million, they were stuck with a large business Chapter 11, they now can qualify for Subchapter 5. And I think that that's going to make a tremendous difference. We're going to discuss how this goes forward. Haley's going to discuss the the requirements for reorganizing and how it happens. I know that there are going to be questions, and so most of you are not going to file bankruptcy. You're going to be creditors. You're going to be looking for, how am I going to get paid? What's the process? How do I get involved? How do I speak up? How do I get heard? And so Haley's going to discuss the process and how the plan moves forward. And I will come back at the end and discuss a few things to sort of clean things up. Haley, you can unmute yourself and I'll turn it over to you.
Thank you, Larry. I also want to mention we do have some materials that were not prepared by us. They were presented to us at a conference recently, and Casey is going to drop those in the comment or in the chat box. Also included in those materials are mine and Larry's biographies, as well as the Subchapter 5 trustee who prepared that presentation. You do not need to follow those, but that may be useful afterwards since we're throwing a lot of information at you guys. So I'm going to start talking about what type of required disclosures the debtor in possession has. I'm going to refer to the debtor in possession as the debtor throughout this just for ease of talking, but that's the small business filer. So every debtor filing bankruptcy, they must make certain disclosures of information, which is usually given to their attorney, such as Larry and I, to process into bankruptcy petition and schedules. So here at CGA, we provide a packet to our clients with questions and easy to follow instructions on what to provide. And I explain it to my debtor clients as data inputting on their end. But on our end, as bankruptcy practitioners, while we're processing this information, we're analyzing that data under the Bankruptcy Code, under this Small Business Reorganization Act, and according to our local trustees and courts rules and preferences, as those may vary among the jurisdictions. We're using this information to prepare and present to the court a realistic, feasible, which we'll talk about feasibility in a little bit, confirmable plan that's proposed in good faith. And that is subject to court order, although the trustee and the creditors do have the opportunity to object. And again, that's probably in your position, any attendees here, you may find yourself being a creditor in one of these Subchapter 5 bankruptcies. So you'll want to know who to call, which is Larry and I, or at least what to look out for. So while our goal is to get our small business debtors into the lowest amount of monthly payments as possible and protect their assets and their equity in the business and keep the business going, our goal is also to create a fair and equitable payment plan, which the trustee and the creditors will be unable to object to. If they do object, we'll work with the trustee and the creditors, or if we're filing the objection, we would work with the trustee and the debtor in possession to resolve it. And again, we'll talk about what those objections can be here in a little bit. So the basic information disclosed by the debtor is the name and the address of the business, the form of the entity and the EIN, the names of the members or shareholders or partners or sole proprietors, depending on what type of entity is filing, along with any other professionals such as the business's accountant. Those will all be disclosed. As for accounting information, income, expenses, properly valued assets, liabilities, and general financial affairs must be reported to the bankruptcy court. And all of that information must be supported by evidence in the form of financial documents. That's our job. Yeah, go ahead, Larry.
If I may, Haley, if you sue somebody, you only get all of that information after you've completed the litigation and you're in some discovery mode for collection. In order to get the protection of the bankruptcy system, the debtor has to provide all of this financial information at the outset of the case, so that upon request, and some of it's actually on record, but upon request, you have all of the information from which you can later decide Is this somebody with which I want to continue to do business? Is this somebody who has lied to me about their financial viability? But all of that information must be provided by the debtor filing the bankruptcy upfront. So you have an opportunity to gauge their ability to repay you, not just their ability to stay open and in business, but to do so profitably and to pay you whatever monetary amount they're going to try and ask you to accept.
Yeah, I agree. Larry and I are in the position that bankruptcy is kind of good for creditors as well, especially if it's in a reorganization such as a Subchapter 5. It's a lot easier to get these documents and object to your treatment. As a creditor, you don't have as many rights as in a regular Chapter 11 that you do in a Subchapter 5, but it's still a beneficial process to get paid. So those financial documents, that's a big part of mine and Larry's job. We need to collect those and be ready for when the case is filed, which we'll discuss the timeline. There's some pretty quick things that need to happen as soon as the case is filed. But the assets and liabilities of the small business debtor, those will need to be supported by a balance sheet. Income and expenses are supported by statements of operation, or more commonly known as profit and loss statements, essentially. Copies of cash flow statements and tax returns are required, and preferably, these are all prepared by an accountant for the business. So if Larry and I have clients who aren't already working with an accountant, we will refer them to one to get situated prior to the filing. That's not always possible in every circumstance. The filing is under emergency circumstances, such as to stop a sale or repossession. The debtor can file temporarily an affidavit under the code that such documents do not exist at the time. Again, to get the plan confirmed, though, the debtor will eventually have to prepare and file those. And similar to a standard Chapter 11, as Larry mentioned earlier, a small business debtor is also required to file monthly operating reports under Subchapter 5. However, those reports will stop after confirmation of the plan. So the timeline, again, it goes pretty quick. So we need to be prepared prior to filing to file what are called first day motions. First day motions, one would be to employ the attorney and the accountant for the small business, as well as any other necessary professionals in the bankruptcy. In order for a professional to be appointed, a professional must be a necessity in the administration of the case, and the cost of that professional must be warranted. So you may be a professional, if you're in attendance today, that you could possibly be appointed one day in a bankruptcy. So this would be useful information for you to know. A professional must also be disinterested and not have an interest adverse to the bankruptcy estate, just like the trustee, as Larry mentioned earlier. Other first day motions are to set a proof of claim deadline. A business has to ask to use their cash collateral on the first day if necessary, or to pay pre-filing wages to a small business's employees. Those are literally on the first day, and a competent bankruptcy professional, such as Larry and I, will be ready to file those. About 3 to 4 weeks post-filing, there is what we refer to as a 341 meeting or a creditors meeting. And this meeting is conducted by the United States trustee, and the appointed Subchapter 5 trustee is in attendance, as well as any interested creditors. Currently, these are being done in a remote setting via telephone or Zoom. We used to go down to the federal courthouse to do those. At this meeting, the principal of the small business debtor will answer questions under oath about the filing, and it's an opportunity for the creditors to ask questions of the debtor under oath regarding the reason for filing, assets, income, expenses, etc. And that's another benefit, as Larry mentioned earlier, to get financial documents. is difficult, you would have to sue that company and obtain them via discovery. Same with a deposition of the business's principal. That is during discovery and litigation. That's essentially what happens at the 341 meeting. You would have the opportunity to essentially depose the owner of the business.
The idea is that if there are questions you have about the financial viability, in theory, by the time you're conducting the creditors meeting, all the schedules have been filed. The debtor is supposed to have provided other information. Normally the creditors meeting, the 341, because it's pursuant to section 341 of the Bankruptcy Code, so it's called the 341 meeting, is half an hour to an hour. If you have, I've seen lawyers show up with their yellow tablets full of questions, and you can have a separate deposition scheduled if you want to really dig into things. But if what you're looking for is to get the major 3 or 4 or 5 questions answered about something, that's what the creditors meeting is for. The U.S. trustee, the Department of Justice, has a checklist, a 2-page checklist of questions that it asks. And so it takes up a certain amount of that time with its own background questions to make sure that it has a handle on all the necessities. But then any creditor is allowed to ask questions, although, again, extensive questioning is done usually at a separate proceeding where the debtor has to appear and answer all of the relevant questions that are asked.
And I think Larry will talk a bit more about the 341 meeting when he's discussing the trustee's role. But again, that occurs about 3 to 4 weeks after the filing. 45 days after the filing, approximately, a debtor's report is required to be filed detailing the debtor's efforts to put together an acceptable plan. And that is a status report that must be filed prior to a mandatory status conference that the court conducts within the first 60 days of the case. So again, all of that stuff is happening within the first 2 months prior to filing. So a competent bankruptcy practitioner will have it all ready to go, or at least in the process of preparing it prior to filing. Within the first 90 days, the small business debtor must then file its plan. So let's talk about the plan. And if you're looking at the materials, I'm going to switch it up a little bit and discuss the terms of the plan first, because it just makes more sense in practice. First, we prepare the proposed terms of the plan, then we seek confirmation of that plan through the court. The plan for a small business debtor is a proposal to the court of a monthly payment, usually for 3 to 5 years. Now I'll talk about consensual versus non-consensual plans later, but let's just focus on the basic terms right now. The proposed plan can later be—
Gilly, do me a favor. Tell everybody, what is the plan supposed to tell you as a creditor? If you read it, what are you supposed to get from it?
Well, the plan's going to tell you how much money you're going to get, right? As a creditor. And that's not really apparent when you look at the plan, which is why you want to have a bankruptcy attorney look at it. I mean, it's a complicated document, and it takes a fairly in-depth calculation to determine what you are going to get as a creditor, or if you're a secured creditor, if you hold a mortgage or a lien on property, if your lien is being modified or possibly removed completely from real estate. So it's important to have Larry and I, or competent bankruptcy practitioner, review these. The plan and its terms may need to be amended along the way to address objections by the trustee and the creditors prior to confirmation, if any are filed. So I'll discuss again shortly what types of objections can be made. But when bankruptcy practitioners such as Larry and I represent small businesses filing for bankruptcy and we're preparing these plans, we're calculating a proposed payment amount based on information provided by our debtor, or preferably their accountant. The plan must include a brief history of the business. It must devote all disposable income to the plan payments. supported by cash flow projections that have been prepared and presented to the court. Now, sometimes the debtor is paying all of its creditors, which we refer to as a 100% plan. And in those cases, the disposable income may exceed what that plan payment is. But often we are just telling the court and the creditors, this is what I have left over at the end of the month. This is what you get. And it might be pennies on the dollar on your claim if you're a creditor. So it's important to have someone look at the plan and look at what financial documents have been presented to determine if you do have an objection to what your treatment in the plan. The plan must also include a liquidation analysis, which I'll discuss in a second, and evidence of the administrative expenses being paid related to the Subchapter 5. So again, the disposable income means whatever funds are left over at the end of the month after the small business's necessary and reasonable expenses are paid. So you have rent, payroll, supplies, equipment leases, maintenance. One of the objections could be to what the owner is paying him or herself. And I'll talk about how to overcome those objections here in a minute. Liquidation value, you've heard us talk about. That means the value of the small business's assets after any liens on those assets are accounted for and after any applicable exemptions are applied. It essentially means if we sold it all, how much is left over for the creditors. Less about 10% for administration of the sale of the assets, that would be applied to that final number. Administrative expenses, such as the Subchapter 5 Trustees Commission, attorney's fees, and accountant's fees. I believe Larry mentioned earlier, one of the benefits of the Subchapter 5 is all of those can be spread over 3 to 5 years. In a regular Chapter 11, that stuff has to be paid pretty much immediately, which is also what made it difficult for small businesses to file. Also in a Chapter 11, under the plan, there are quarterly fees due to the United States Trustee's Office, but those quarterly fees to the U.S. Trustee are not present in a Subchapter 5. One of the huge benefits of the Sub 5 plan is that if the debtor's individual owner has a lien on his or her residence due to a personal guarantee on a business debt, that lien can be decreased or removed from the property completely in the Subchapter 5 plan. And finally, in the plan, there needs to be some sort of remedy listed or more than one remedy to the creditors, just in case the debtor defaults under the plan, which is not out of the ordinary. One remedy mentioned in our materials that are attached is a provision that the non-exempt assets of the small business may be liquidated upon default under the plan. So as creditors counsel, we would be pushing for remedies that make it easier for our clients to liquidate the assets or otherwise get paid more quickly and efficiently upon debtor's default, because otherwise there might be too long of a cure period allowed, or your only remedy may be having to take that plan to state court and sue under the plan where the state court judges are not proficient in bankruptcy law. On the other hand, as debtors counsel, if we're representing the small business, we're looking for more debtor-friendly remedies in the plan, which would take longer to execute upon by creditors and thereby allowing longer cure periods for any default. So we will be looking at these plans a little differently depending on who we represent. So those are the basic terms of the plan. Let's talk about the confirmation process. As Larry discussed earlier, in a standard Chapter 11, the debtor must provide that 25-page document, the disclosure statement, to the creditors, who then review the plan, and all of the creditors actually vote on whether or not it's acceptable. But in a Subchapter 5, that power actually shifts to the court to decide whether the plan is acceptable or confirmable. So therefore, the onus is on the small business debtor to disclose all of that required information I discussed earlier to show them this is all I have left to pay to the creditors every month. Some of these plans could be quarterly, depending on how the plan is set up. So if a small business is paying a lot of creditors, pennies on the dollar, it may be more efficient to do that quarterly rather than every month, especially if it's the trustee who's having to write those checks. I don't think the trustee would object to only doing that quarterly. It depends on who your trustee is, but I spoke to our US trustee in our district, and he would allow for quarterly payments. So while ultimately it is in the court's power to confirm the plan, as I have mentioned throughout, and as Larry has mentioned, the trustee and the creditors do have an opportunity to object to that plan. Eventually, this process will determine whether the plan is being confirmed consensually or non-consensually. The goal in any Chapter 11 is to create a consensual plan where all of the creditors are accepting their treatment of the plan. But in a sub 5, a non-consensual plan can still be confirmed if it does not discriminate unfairly amongst the classes of creditors, and if the plan is fair and equitable with respect to each class of claims. So classes of creditors could be, in general, unsecured claims, priority claims, secured claims, leases, executory contracts. I think I've covered them, Larry. Please.
Well, and it's important to note the point that you just made, Haley, which is in a large Chapter 11, if you can't garner enough creditor votes, you can't get the plan confirmed. You have to get yes votes from the creditors, and all it might take is one large creditor voting no, and you fail the percentages that need to be garnered to approve. Here, the court can actually take the negative votes and say, I still think the plan is fair and equitable, so I'm going to confirm it even though you voted no. That puts in some extra protections that Haley's going to discuss, but the plan itself can still be confirmed.
Agreed. Exactly. That's one of the huge benefits. And the non-consensual plan in the bankruptcy world is also referred to as the cram down plan. And it pays the creditors, again, that disposable income we discussed previously, which may only pay them pennies on the dollar. And the difference in consensual and non-consensual plans is there are several differences. One could be when the debtor receives the discharge. So in a consensual plan, the debtor is going to get its discharge upon confirmation of that plan, move on with its life. But upon the last payment made after 3 to 4 years in a non-consensual plan is only when the debtor receives their discharge. Consensual and non-consensual plans are different when it comes to when the trustee's duties are over, which Larry will discuss here soon. But again, all of that is, we do that every day. So if any of you are involved in a filing or trying to navigate one of these, please don't hesitate to reach out. So let's talk about objections to the plan. Some objections may be to the valuation of the debtor's assets. So as bankruptcy practitioners, we resolve these objections through either settlement negotiations or through dueling appraisals if necessary. Other objections may be to payments made to the insiders or principals of the business, which I mentioned earlier. We resolve these objections by showing pre-pandemic salary, whether the principal took a pay cut trying to salvage the business, giving evidence of reasonable salaries for the position from a resource such as salary.com could be evidence. Even experts could be used if necessary to establish reasonable payments to small business owners. Other objections may be to whether the expenses reported are reasonable and necessary expenses, and creditors can seek validation of those, at which point, representing small businesses, we would provide such validation and evidence of reasonableness in the industry and under the circumstances. each case is so different and new issues arise in every filing. So it keeps us on our toes. Other issues the trustee, the creditors, and the court may consider when confirming a plan is the proposed repayment schedule feasible based on the small business's financial planning and revenue estimates? Can they afford it, is the question. Does the plan protect the best interests of the creditors by repaying them at least as much as they would get if the business was liquidated under a Chapter 7?
And
Is
what
the
I'll,
plan,
what,
yes,
so what I'll point out is that while some small businesses have assets, most of the time the assets are tied up by the bank. And what the unsecured creditors are really going to be getting is some return on the labor of the principal. The principal is working his or her small business to turn some sort of a living wage and hopefully a profit that gets put into a plan. So in many, many ways, it's not, I mean, the liquidation analysis is, I mean, it's done on the hard assets, but what you're really trying to value is the worth of the labor of the individual who wants to try and keep their small business alive.
so after we talk about the best interests of the creditors, we're going to consider, is the plan fair and equitable to the creditors? Is it providing secured creditors or the creditors who have liens adequate protection? And adequate protection, we call that equity in the assets, or whether the debtor is making sufficient monthly payments to cover that collateral. And the overarching question is, was the plan proposed in good faith without a questionable motive, such as avoiding payments you could actually afford or buying time when the plan is ultimately unaffordable or unfeasible? A lot of factors go into that good faith, bad faith analysis, and we're constantly having to deal with that in bankruptcy litigation.
Haley, I'm going to guess that most of our audience, they're creditors, they're small businesses, they're the people that are owed the money. So if I'm going to attack something, where am I looking to attack? If I'm going to try and find a hole, what am I going to be looking to try and accomplish? Where do I go?
And there's also the question of fraudulent transfers, which is a fairly in-depth analysis. So if you as a creditor suspect that the small business debtor has not been completely honest in the process, that's one of the things you want to talk to Larry and I about, so we can perform some discovery and figure that out. Possibly have to file an adversary proceeding to litigate that. So, but those are basic objections to the plan that can be made. There are a number of them, but if these objections can't be resolved beforehand, a hearing will be held. The court will decide whether the plan is confirmable above those objections. Even post-confirmation, the plan can be modified essentially through the same process if circumstances change. So I am going to turn it back to Larry to discuss the trustee's role, I believe.
Okay, and I don't see any questions that have come across, although I see some things in the chat room. So maybe Haley, you want to take a look at those in the meantime. Let's discuss a little bit about the role of the trustee. As I said in a garden variety chapter 11, the function of the trustee is really to act as only taking over if the debtor has failed. The debtor gets to run their own business in a normal chapter 11. And if I'm appointed as a trustee, it's because there's been substantial cause. There's been some fraud, there's been some mismanagement, there's been something that has happened. So usually when I come in as a chapter 11 trustee, I'm walking into a disaster. I'm walking into a management dispute. I'm walking into a situation where the owners of the company have simply failed in their attempt to put together anything meaningful in the way of a reorganization. So in a small subchapter 5, the trustee is almost a mediator to try and come up with a resolution for what seems to be fair and equitable. I've not been a trustee in a subchapter 5, because there's a separate panel of attorneys that do that. But in talking to them, what they're supposed to do is to be an independent investigator, if you will, so that they actually go in and recommend, after meeting with the debtor, looking at the books and records, recommend an independent payment plan to the creditors. In effect, go in and say, I will verify the accuracy of what I've read. I've talked to the debtor. This is how I think that here's enough that here's what the debtor can afford to live on. Here's what the debtor can afford to put out on the table so that the creditors are getting paid something. You may or may not, as a trustee, talk to the secured creditors about restructuring the equipment loan so that the equipment can be affordable, so they can retain it to run the business. Many small businesses still have equipment, trucks, construction equipment, small things like that. And so you're looking at, maybe you need to knock the interest rate down, or you need to extend the payments, or you need to make this cash flow affordable. The object I wrote down from the statute is to facilitate the development of a consensual plan of reorganization. Now, Haley discussed that plans can be consensual. That is, everybody agrees to it. A plan can also be non-consensual, where a creditor says, you know what, I just don't like the way I'm being treated. It's not fair. But as long as the trustee suggests that the plan should be confirmed, and as long as the court doesn't feel there's some impingement or infringement upon the rights of the creditor, a non-consensual plan can be recommended by the debtor and the trustee and can be confirmed by the court. So as I said, in a regular Chapter 11, you're either dealing with the debtor or the trustee. And in a Subchapter 5, you're actually dealing with the debtor and the trustee as a facilitator, mediator, whatever you want to call it. Now, it's still possible for a Subchapter 5 debtor to mess it up. And so it is possible to remove the Subchapter 5 debtor and to have the business still be operated by the trustee. But the smaller the business, I've come to realize that the more the business many times is the debtor. It's not a sole proprietor necessarily, but it may be a family-run business. It may be small enough that if you remove the principal, that a lot of other people go along and leave as well. Usually, at least in my experience, before Subchapter 5, when I happened to be appointed as trustee for small businesses, most of the time my mandate was sell the assets, shut it down, sell the assets. And so I would assume in a Subchapter 5, you're going to have the same thing. What I think that does is, I can tell you that the minute you shut something down, you wind up lowering the value of whatever you're trying to sell. So in many cases, that consensual plan may be the better way of getting something than getting nothing. Realizing that if it's a problem, keeping the debtor open at any time, the principal might just say, you know what, I'm going to go home. I'm not going to worry about this anymore. I'm going to go get a job. And in fact, I've seen a number of principals, owners of small companies, go get a job doing whatever it was they did for some bigger company and doing it well, getting a good job with a paycheck. They put their small business out of business. They file a Chapter 7 themselves for whatever guarantees they've given, and they move on with their lives. So in many cases, the incentive for the creditor is to figure out a way to get something. It sounds horrible, but I actually one time used the phrase that this is milking a cow. Sometimes it's better to milk the cow. Sometimes it's better to butcher the cow. And you have to figure out exactly which case you have, to the point that I have a client, I'm not going to show it to you, but I have a client that gave me a wooden cow as sort of a token for the advice that I had given. So are there any questions that, Haley, we need to respond to in the chat room?
No, I don't see any questions.
Okay. Well, I have 5 minutes of the hour, and I don't want to continue to talk just for the sake of killing the hour. There's no CLE credit here. I think we've covered the material, and we've, I think, given everybody an overview. If you wind up being a creditor in a Chapter 11, it's a slower moving process, and you've got lots of time to think about it. If you are the creditor in a Subchapter 5, you need to act a little more quickly. You need to be a little more on your toes about looking into what's going on and what's happening. Understanding, however, that the trustee can be approached. You can go to the trustee and say, what do you think? What are you looking at? What's it look like we're going to be getting? And I think there's probably a little more room for what I would call horse trading in a subchapter 5, where a consensual plan has a lot of advantages for both the debtor and the creditors. And then there's probably an encouragement to come together using the trustee as the fair and honest broker as to what's a reasonable resolution based on what you see happening here within the debtor's business. Haley, any final remarks from you?
No, I just wanted to mention that, again, this is beneficial for not only small businesses who are struggling, but creditors, even professionals who might be appointed in a bankruptcy, possibly those who are interested in purchasing bankruptcy assets or loaning a small business money. Those are all things you can call us for. Please don't hesitate to reach out. And I appreciate those who are in attendance today. Thank you for taking your lunch hour. Maybe next time we do this, we can serve you lunch.
And our email addresses, by the way, are very easy. It's hrohrbaugh@cgalaw.com and lyoung@cgalaw.com. Feel free to reach out if there's a question you didn't want to ask or you think about it later. More than happy to stay in touch. Casey, we'll turn it back to you, I guess.
Thank you both so much. This was quite thorough, informative, and very enlightening. So I appreciate you both taking your time to share with our audience your insight and professional knowledge. I will send a follow-up email with those email addresses linked in the event anyone wants to reach out to you directly, just make it a little easier for them. But otherwise, I hope we'll see you all next time. Thank you again and enjoy your Thanksgiving.
Thank you. You also.
Thank you. Happy Thanksgiving, everyone.